Hello everyone. Continuation to the second chapter of a company law, we can see doctrine of ultra-vires. Ultra-vires is a fundamental concept of a company law that refers to an action taken by a company that go beyond the scope of its legal authority as defined in a memorandum of association. And what are the key points? First, see what is the definition of this. Ultra-vires is a Latin term which means beyond the powers. In the context of the company law, it refers to any action or the decision taken by a company that is beyond the scope of its legal powers and objectives. Memorandum of Association, limits of an authority, void and enforceable. MOU is a fundamental document that outlines the company objectives, powers and scope of a business activities. It defines company's legal capacity. The doctrine of ultra-vires sets a clear limits on what a company can do and cannot do. Any action or a transaction that falls outside the scope of the company objective considered ultra-vires, and actions that are ultra-vires are generally considered void and unenforceable, legal validity and cannot be ratified, validated by the company. Shareholders and the directors' liability is there, historical significance, and there are certain kind of exemptions. Modern company law includes memorandum of association that grants companies very broad general objectives, allowing them to engage in a wide range of activities. This has reduced the applicability of the ultra-vires doctrine. Alteration of memorandum. In some jurisdictions, a company may be alters the memorandum of association to expand its objectives, and such alterations typically require approval by the shareholders or other regulatory bodies. And the doctrine of relevance, we can say about that, relaxed in the modern company law, and it remains important for ensuring the companies operate within the legal framework, do not exceed upon unauthorized powers. Constructive notice and indoor management will come under a fundamental principles of a companies often use to balance the interest and protection of third parties dealing with the companies. Doctrine of constructive notice stands, and this implies the third parties dealing with the companies are deemed to have a knowledge of a company's publicly available documents, including in memorandum and articles of association, register of members and registered charges. Protection for the third parties. The doctrine is meant to protect third parties who enter into a contracts or a transactions or the contracts with a company with a good faith. They are expected to have a knowledge of the company, public documents, and are presumed to rely informations contained in these documents. Responsibility of the management also will be including of a directors, officers responsible for ensuring the informations in these public documents accurate to up to date. And indoor management stands the complementary principle that offers protection to third parties which rely on the internal management and decision making process of the company. It operates contracts the doctrine of constructive notice. Protection of the third parties also comes under the particular apparent authorities of a company officials and the internal management produces procedures of a companies. If a company internal procedures are not followed, it is an internal matter and should not affect the rights of a third parties. And you can also say that internal management balance protection. Third parties need a company's internal affairs to be handled efficiently, independent by the company law itself. Limits of the doctrine also can be taken under the limit under internal management systems, and the doctrine has a limits. Finally, a certificate of incorporation given by the registrar shall be conclusive evidence that all the acts required have been compliant with the inspect of a registration and that association is a company authorized to be registered under the act. Thank you.